If you were born before 1960, I need you to stop what you are doing right now and stay with me for the next 12 minutes because there is a very real chance that the home you have spent 30 years paying off can be seized by the state over a nursing home bill you never saw coming. Not a theoretical risk, not something that happens to other people. I am talking about a federal program that places liens on tens of thousands of homes every single year, and nobody from the government is going to pick up the phone and call you to tell you about it. That is not how this system works. The system waits until you are gone, then sends your family a letter, then forces the sale of the house, and the inheritance you thought your kids were going to receive just quietly disappears. Today, I am going to show you exactly why this happens, how to find out if your home is already exposed, and the specific steps you take to protect it before another month goes by. Stay until the end. The last step is the one almost nobody takes, and it is the only step that actually removes your home from the government's reach permanently. If you are not subscribed yet, do that right now and turn on the bell. Medicaid rules, estate recovery procedures, and look-back regulations change every single year. When they change, nobody from the government explains what it means for your specific situation. That is exactly what this channel does. Subscribe, and let's get into it. Before I get into the details, let me tell you about something that happened last year that I think about a lot. A retired school teacher in Toledo named Margaret had been living in the same home for 41 years, paid off the mortgage in 2003. She and her husband built the place from nothing. He passed in 2018. She stayed. Last March, she had a stroke and needed skilled nursing care. The national median cost is over $9,700 a month, $116,000 a year. She applied for Medicaid. They approved her care but denied her protection. Not because she did anything wrong, because 11 years earlier, in 2014, she had added her daughter to the bank account so the daughter could pay her bills if she ever got sick. Helpful, practical, common. But when Medicaid ran the 5-year look-back, they treated half of every deposit in that joint account as a gift from Margaret to her daughter. The penalty period worked out to roughly 7 months. 7 months where Margaret had to pay privately. At $9,700 a month, that is almost $68,000 she did not have. The family had to sell the house. Margaret's story is not unusual. It is, in fact, far more common than most people realize. And the reason it keeps happening is the same every time. Nobody told her to check. Here is the foundation of everything I am going to explain today. The program that takes these homes is called Medicaid Estate Recovery. It was created in 1993 under the Omnibus Budget Reconciliation Act. Every state is required by federal law to recover what Medicaid paid for nursing home care from the estate of anyone who was 55 or older when they received benefits. The house is the biggest asset in most estates, so that is what the state comes for. In 2023 alone, state Medicaid agencies recovered over $700 million from families just like Margaret's. And according to data published by the National Academy of Elder Law Attorneys, roughly 60% of families facing estate recovery lose the home entirely. If your home has any equity at all, you are in the crosshairs. One analyst ran the numbers and found that a single nursing home stay averaging 2.5 years can wipe out close to $300,000 in home equity. Over a 30-year mortgage, that is a lifetime of payments gone. Not because you did anything wrong, because nobody told you the rule existed. Now, I want to tell you about the practical companion to everything in this video. The Inheritance Quick Shield Guide walks families through every scenario I am about to cover. The 5-year look-back audit worksheet, the deed and title review checklist, the transfer on death deed walkthrough for your specific state, the caregiver agreement template. The outcome is simple. Your kids inherit the house you spent your life paying off. The state gets nothing. The letter never arrives at their front door. Link is in the description. Now, let me add the second layer to this, because for people born before 1960, there is a specific calculation issue that has quietly cost millions of families their homes. And it comes down to one window that most people never fully understood. If you were born anywhere before 1960, you are currently between 65 and 85 years old. That is the exact age range where the risk of needing nursing home care rises sharply. The lifetime risk of a nursing home stay approaches 50% for adults over 85, and the federal government gave you a window to protect your home. That window is called the Medicaid look-back period. 60 months, 5 years. Every financial move you made in the last 60 months is on the table. Every gift, every transfer, every sale below market value, every account you added a child to, every trust you set up. Here is the problem. The Social Security Administration is not the only government agency that sends you a number and expects you to accept it. Medicaid does the same thing. When you apply for benefits, they run the look back. They find the transfers. They calculate the penalty. They send your family a number. And by the time that number arrives, it is too late to undo any of it. What many of those people were never clearly told is that the 5-year look back does not just examine large transfers. It examines everything. A $10,000 gift to your grandson for college, a $30,000 contribution to your daughter's down payment, a $5,000 check to your church above your normal giving. The annual gift tax exclusion in 2025 is $19,000 per person. From an IRS standpoint, you owe 0 gift tax and file 0 forms. From a Medicaid standpoint, every single one of those transfers created a penalty. 2 completely different government programs, 2 completely different rulebooks. If you made a $50,000 gift 3 years ago and your state's average monthly nursing home cost is $10,000, that is a 5-month penalty. 5 months times $10,000. That is $50,000 out of pocket. The exact same amount you gave away, except now you do not have it anymore. Last spring, a man in Phoenix named Robert posted in an elder law forum that he had been caring for his wife at home for 3 years. He had been paying his niece $500 a week to help. No written agreement, no U-2, no 1099, just cash every Friday. When his wife eventually needed full nursing home care and they applied for Medicaid, every single one of those payments was treated as a gift. 3 years of weekly payments, $78,000, divided by the state divisor. That is a 7 or 8 month penalty. Robert said, and I am paraphrasing what he shared publicly, that when he set up the arrangement with his niece, no one at the bank or anywhere else sat him down and said, here's what this costs you if your wife ever needs Medicaid. He was just writing checks and assumed it would be fine. He said he wished someone had explained it the way an attorney finally did, 30 minutes over a consultation. That story hit a lot of people because it is not an edge case. It is one of the most common ways families get blindsided, and it has a specific shape for people in this birth year range. Now, I want to be direct about something. If you have already made transfers, already added a child to your deed, already set up a trust years ago, I am not here to make you feel bad. What I am here to do is show you that there may still be protection available for reasons that have nothing to do with what you did wrong. Because here is what most people do not know. Even if you made mistakes inside the 5-year window, even if your trust does not protect you, even if your deed exposure is already in place, there are still tools that work. And that is the fixable part. That is the part an elder law attorney can actually do something about if you bring them the information before the crisis hits. So here is what I want you to do. And this is the part of the video you should be writing down. The first thing is to go pull 5 years of bank statements, every account, every transfer, every check written to a family member that was not a documented loan repayment. Write down the date and the amount. This is your look-back exposure. If the number scares you, you need to start planning now, not later. This takes about an hour if you have online banking. The second step is to check how your home is currently titled. Go to your county recorder's office website, search your name, look at the deed. Is your name alone on it? Is a child listed as joint tenant? Is it held in a trust? The way your house is titled today is the single biggest predictor of whether your family keeps it or loses it. If a child is on the deed, you have exposure to their divorce, their creditors, their lawsuit, and Medicaid penalty. The third step is to find out if your state offers a transfer on death deed. Over 30 states plus the District of Columbia do. It is a single-page document. It names who gets your house when you die. It bypasses probate entirely. It costs nothing to file in most jurisdictions. It takes about 15 minutes to fill out. No attorney needed in most states. The form is available on your state's Bar Association website or your county recorder's office. Once you submit it, your home skips probate. No judge, no public record, no 6-month wait, no easy path for estate recovery to attach a lien. Now, here is something important about timing that I do not want you to miss. While some strategies can still work even after a crisis hits, the Irrevocable Medicaid Asset Protection Trust only works if you set it up at least 5 years before you need nursing home care. The day you sign, the clock starts. If you do not need care for 5 years and 1 day, the house is protected. Medicaid cannot touch it. Your kids inherit it. The catch is that you cannot take it back. You can still live in it. You can still sell it with the trustee's permission, but you cannot change your mind and pull it back into your name. That means the older you are when you start, the higher the risk that the clock does not run out in time. This is not a reason to panic. It is a reason to move on this sooner rather than later. If Margaret in Toledo had set up a trust 11 years ago instead of adding her daughter to the bank account, the house would be protected today. I also want to address something that comes up every time I cover this topic, which is the federal estate tax exemption time bomb. The Tax Cuts and Jobs Act of 2017 doubled the exemption to roughly $13.99 million per person in 2025. That law is set to expire at the end of 2025. Unless Congress acts to extend it, the exemption drops roughly in half in 2026. For a married couple, the protected amount falls from around $28 million down to around $14 million. The important thing to verify is whether your estate is anywhere near that number. A family business, a farm, a couple who owns investment property plus their home. Combine all of that, and you would be surprised how fast the numbers add up. In May of this year, a report from a Congressional Oversight Office confirmed that thousands of families with estates between $7 million and $14 million would be dragged into the federal estate tax net for the first time when the exemption drops. The Treasury Department itself acknowledged the problem. Those families did not do anything wrong. They saved, they invested, they planned, and the math inside the tax code is shifting under them. The Inspector General estimated that roughly 40% of estates in that range may be affected. 40%. That is not a rounding error. That is a systemic shift that the government quietly acknowledges when pressed, but does not go out of its way to publicize. This is the part I want to stay with you after this video is over. Medicaid is not your adversary. The estate recovery program is not malicious. Most of the people who work there are trying to do their jobs, but the system is enormous. It is complex. It was built on decades of federal mandates and state-level bureaucracy. And the honest reality is that it takes homes from real families every single day. The burden of protecting your home does not fall on Medicaid. It falls on you. And the only way you protect it is by acting before the crisis hits. If you were born before 1960, your window is 5 years. Your home was supposed to be protected by the planning you did decades ago, correctly structured and correctly timed. Before you close this video, go pull your bank statements for the last 5 years. Check how your home is titled at the county recorder's office. Find out if your state offers a transfer on death deed. If you see something that does not look right, it probably is not. The form to fix the deed is the transfer on death deed available through your county recorder. The number to call for a 5-year look-back audit is a qualified elder law attorney in your state, not a general practice attorney. Not the attorney who set up your will, an elder law attorney. Send this video to one person you love who was born before 1960 and owns a home. One share takes 10 seconds. If their deed has even one exposure we covered today, catching it could save the family home permanently. Money the state has been positioned to take without sending a single letter to warn them about it. That is what this channel is here to do. If this made a complicated topic easier to follow, subscribe and hit like. The Inheritance Quick Shield Guide has the checklists, the audit worksheets, and the document templates we covered today. Link is in the description. I will see you in the next one.